Hello, welcome to Business Law 1 class. Today we look at Section 6 of Unit 1, Arbitration Proceedings in Ghana. Session Objectives. By the end of this session, you should be able to understand arbitration in Ghana, how arbitration agreements are arrived at. Now, you should understand that the law that governs arbitration proceedings in Ghana is the ADR, Alternative Dispute Resolution Act 2010, Act 798. This is the law that governs the arbitration proceedings. So it also applies to both domestic and international arbitration. Now you should also understand that the basis of our ADR Act also include the certain provisions, or it is based on certain provisions like the ancestral model law, on convention, on international commercial arbitration, with certain amendments. Also adopted an United Nations Convention on Recognition and Enforcement of Arbitral Award, that is the New York Convention. So if you pick our ADR Act, it contains the New York Convention 1958. It also contains provisions on the Geneva Convention and the Convention on Settlement of investment disputes between state and nationals of other states. So the ADR Act contains some of these laws. You should understand that arbitrators are required to decide cases based on chosen laws by the parties. The law that will be chosen by the parties is what the arbitrator will follow. So the arbitrator must apply the chosen law by the party as the applicable law to the substance of the case. So the parties may state the applicable law should be the laws of Ghana. So the laws of Ghana becomes the applicable law that they have chosen. The arbitrator must also decide disputes in accordance with other considerations as agreed by the parties or determined by the arbitrator. So other factors that the parties or the arbitrator will determine must also be taken into consideration. As we indicated earlier on, it is not all disputes that can be resolved by ADR. Therefore, Section 1, this section everybody must know. Section 1 of the Alternative Dispute Resolution Act 2010 at 798 stipulates that the Act does not apply to the following matters. It means that when it comes to the following issue, that's issues of national or public interest. 1. Issues relating to the environment. 2. Enforcement and interpretation of the Constitution. 3. And any other matter that by law cannot be resolved by alternative dispute resolution. 4. Like here you can cite example like rape. All these cases you cannot resolve using arbitration. You cannot resolve issue arbitration. The essence is that enforcement and interpretation of the Constitution is vested in the Supreme Court. When it comes to this matter, for rape, for instance, High Court has jurisdiction. Environmental issue, High Court has jurisdiction. Issue of national interest, the court has jurisdiction. So we don't entertain the use of ADR to resolve this issue. Now let's look at the validity requirement of arbitration agreement. So for an arbitration agreement to be valid, what are the requirements that you have to meet? So the requirements are the parties must consent to resort to arbitration. So they should give consent to the fact that they have all agreed to resolve the issue through arbitration. It should be voluntary. Parties must have legal capacity. If you don't have capacity, you cannot enter into an arbitration agreement. The agreement must be in writing. Before you go to arbitration, then you should have a pre-existing agreement in writing. Or sometimes the court may also refer you if you other parties consent to. The subject matter must be one which can be arbitrated by law. So you are here saying that the subject matter of the arbitration should be the one that can be arbitrated by law. It means that any of the provisions that we mentioned under section 1 of at 798, that is issues of national interest, enforcement of constitutional interpretation, environmental issue, it should know they are the issue that cannot be resolved by ADR. So if the subject matter consists of those issues, then you cannot use that one to use ADR to or arbitration to resolve. However, if it doesn't fall within those matters, then it can be arbitrated by law. So these are the 4 requirements we have to meet. You should also understand that while there is an arbitration agreement and a party commences an action in court, the other party can on notice to the other party who commenced the action apply to the court to further action or the part of the action to which the arbitration agreement relate to arbitration. What this provision means is that, look, if there's an arbitration provision that when there's a dispute, you will settle the case through arbitration, and one party and there's a dispute or there's a breach of contract, and one party first initiates action at the court, the other party can notify the one who has commenced the action that we agree to resolve dispute through arbitration. So the person has a right to apply to the court that the court, we have agreed to resolve. If you have arbitration court say that dispute will be resolved at arbitration, so please refer the matter for it to be resolved at arbitration, and the court will do so. So if the court realizes that an action is the subject matter of arbitration, the court must take proceedings and refer the parties to arbitration. So if the court notices that, look, application has been made and indeed evidence has been given that there was an arbitration provision, then the court must stop the case and refer it to arbitration. Sometimes it is only part of the case that must be resolved through arbitration. The court will refer that portion of the dispute to arbitration and resolve the remaining in court. You should also understand the competence rule under section 24 of Act 798. It allows the arbitral tribunal to decide on whether or not they have jurisdiction or not. So when you raise objection that, look, arbitral tribunal, you don't have jurisdiction to sit on the matter, the competence rule allows the arbitral tribunal to determine whether or not they have that power. So the arbitral tribunal has the power to examine and decide in the first instance any objection to their jurisdiction. So if someone says, look, arbitral tribunal, you don't have jurisdiction on this matter, the same arbitral tribunal has the right to decide whether or not they have the right to sit on the matter. However, the parties are afforded the opportunity to resort to the court for review of the arbitrator's ruling on competence or at the stage of setting aside the award given by the parties. So this is what you are saying. If the arbitral tribunal relies on competence to decide that they have jurisdiction, then the party who is not satisfied may apply to the court to challenge that decision. Or in case it has given award or that judgment, you apply to set aside. You should also understand that arbitration agreements will usually set out the procedure for selecting arbitrators. So if there's an arbitration agreement, the agreement will tell you how the arbitrator should be selected. Maybe one party will select one arbitrator, another party will select one arbitrator, and the two arbitrators selected will appoint another arbitrator who shall be the chairman. In the absence of a provision in the agreement, that the parties may decide when the dispute arises, following which the appointment shall be made by appointing authority upon a request by a party. Now, you should also understand that parties can agree on the qualification, number, and characteristics of the arbitrators. So they are going to appoint the arbitrators. They can put in certain qualification, what the requirement that the person must possess before the person can sit on the matter. It is up to the parties to decide. Notwithstanding, the ADR Act prescribed that 3 arbitrators and an arbitrator need not to be national of or licensed to practice in Ghana to serve as an arbitrator. So we should have an odd number, so you can get the Act provide for 3 arbitrators. So each party provide 1 and the 2 appoint a third one. But you don't need to be a national before or licensed to practice in Ghana before you can be an arbitrator. Also, because the parties have appointed arbitrator, they can also state the circumstances under which the appointment will be revoked. They appointed you and they can also withdraw that appointment. So you should understand that the arbitrator's authority terminates if the arbitrator withdraws from his office or the parties terminate the agreement in writing or the arbitrator fails to sit within a reasonable time. So 1, his appointment will be terminated if he withdraws from the office. 2, if his appointment is terminated by parties in writing, not oral. 3, the arbitrator failed to sit within a reasonable time. You have been given 2 weeks to start the proceedings. Then you wait 1 month before you start the proceedings. It is not within a reasonable time. Your appointment will be said to be terminated. Now, conflict of interest and arbitrator. You should understand that where a person is requested to be arbitrator, that person shall disclose in writing any circumstance that is capable of affecting the person's independence and or impartiality. So if you have been appointed and there is a circumstance that will cause you to act independently or you'll be biased in making the decision, then you have to disclose. Therefore, from the time of appointment and throughout the arbitral proceeding, the arbitrator shall not, without any delay, also disclose to the party in writing circumstances likely to give reasonable cause to doubt as to his independence and impartiality. What this second provision means is that, look, if even at the time of accepting the appointment there was no issues of independence or partiality, now along the line, if circumstance arise and if you think that because of that circumstance you can't act independently or you may be biased in making decisions, then you have to inform the parties. You should also understand that there are arbitration organizations in Ghana that we often make reference to, or outside Ghana. We have the Ghana Arbitration Center as one. That's the one we have in Ghana. Then we have the London Court of International Arbitration. We have the ICC International Court of Arbitration at Paris. Then you have Permanent Court of Arbitration, the Hague. That's where it can be found. So these are some of the main organizations as far as arbitration is concerned. Now, as I indicated, the decision given by the arbitrator is called the award. However, the parties are able to agree on the form of the award, and in the absence of the award, such an agreement and alternative dispute require that award shall be in writing. So the parties may say, oh, the award should be oral. It is accepted. But if they don't give anything, any provision, then it should be in writing. And I'm saying that the arbitrator shall sign the award. So the arbitrator will append his signature on the award and also state the date and the place where the award was made. So the date, the place where it was made, and should be stated in writing, and reason for that award. Give reasons why do you arrive at that decision. Also, in making the award, the arbitrator may, within the scope of arbitration, grant any relief that arbitrator considers to be just and equitable. So the arbitrator will consider any other circumstance that will help him to make just and equitable decisions. It means that when applying the applicable laws, it will not lead to a fair judgment. The arbitrator has the right to apply the principles of equity to make judgment. So you have to note that one. Now let's look at the grounds for challenging arbitral award. So arbitral awards are final and binding. The award given is final and binding. It means that the parties must necessarily follow the decision of the arbitrator. The arbitral award, a party cannot appeal against the merits of the award. You cannot appeal. You cannot ask the court to rehear the matter again. However, you can challenge. There is a difference between you challenging the court and you appealing to a court. You challenge on the grounds that a party was under some disability, like one part or incapacity. The person was an infant, the person was intoxicated at the time of the proceedings. You can also prove that, if you can also prove that the law applicable to arbitration was not valid, then it will be a ground for the court to set aside the judgment. Another ground is that the applicant was not given notice of the appointment of the arbitrator or the proceedings, or was unable to present the applicant case. So if one of the parties was not given chance to participate in the appointment, that's only one side appointed the arbitrator, or if the party was not given the chance to present his case, it can be a ground to set aside the arbitration proceeding. You should also understand that where the award deals with a dispute not within the scope of arbitration or outside the agreement, except the court shall not set aside any part of the award that fall within the agreement. So this is what the law is saying. Look, when the arbitrator goes beyond its powers, you have been asked to settle case A, then you go and settle case B. That decision will not bind. That decision will not bind the party, because that was not the decision that you were told to adjudicate on. Or if you have three issues, settle A, B, and leave C. If you settle all the three, the C will be taken out, will be set aside, because the instruction does not cover the last one, which is the C. Also, failure to conform to the agreed procedure by the party. Maybe the party has laid down procedure for the arbitrator to follow. If he fails to follow that rules, it can be a ground to set aside the arbitration proceedings. You should also know that where the arbitrator has interest in the subject matter, which the arbitrator failed to disclose. So as an arbitrator, if you have an interest, that is conflict of interest, and you fail to disclose, that it can be a ground for the award to be challenged. In all cases, if you want to challenge the arbitration agreement, you have to challenge within 3 months after judgment has been given. Unless with a justifiable cause you state. So it means that after the 3 months, and you can give the reasons why you were not able to challenge within 3 months, the court will accept. But now you have to challenge. If you want to challenge, you have 3 months to do so. Now, you want to look at the recognition and enforcement of awards. An application or notice must be made to the High Court for enforcement of an award. So if you want to enforce it, you have to apply for notice, make application or notice to the High Court for enforcement. So upon successful application for enforcement, the award may be enforced in the same manner as judgment of the court. So if you make application and the court adhere to or grant your application, it will be enforced as if the judgment is a judgment from the court. Session summary. We have looked at arbitration and some of its related issues. Thank you and have a wonderful day.